So we are discussing the questions of your unit number 1 of partnership. The first question that is given in your context is, Mr. XU and Mr. YU are partners in a partnership firm. XU introduced MU, an employee, as his partner to ZU. So now first we will be seeing how the things are going in this firm. So there is a firm. There are two partners, XU and YU, right? XU has introduced MU as the partner. These two were partners. As the partner, he said that this is also our partner, and he introduced it in front of ZU, right? This is the client, you can say. MU remained silent. MU didn't deny that I'm not the partner, I'm just an employee. He didn't say anything. ZU, a trader believing MU as partner, supplied 50 laptops for to the firm on credit. Now this is your trader, so you can call it, instead of client, we'll just call this person as creditor. Why is it not working? So now your ZU is your creditor, and creditor has supplied you, the firm, he has supplied to the firm 50 laptops, seeing that MU is the partner. He doesn't know that XU and YU are the partner. He knows that your Mr. MU is also the partner of the firm. Now, coming to the context, after period of expiry, credit period, after expiry of credit period, ZU did not get amount of laptop. Now this person, your creditor, you have not repaid anything to the creditor. Now creditor will come and demand the money, but whom he will demand? He will demand to MU. He'll tell MU, give the money, because you are also the partner of this firm. Now you also have to give the money. Now this creditor supplied 50 laptops, believing MU is the partner. MU is the partner. Okay. Now this is the Reliance. Now he has supplied you 50 laptops, and after he might have given you 2 months of credit period. He might have given the firm 2 months credit period. 2 months credit. Now this credit period has expired. Still the firm has not made the payment. Now what ZU will do? He will go and talk to XU and also to MU. He will file a case against XU and MU because he thinks that XU and MU are the partners for the recovery. Now tell me, will MU be liable? Should MU also pay the money? He is an employee, but he was shown as a partner. Now this creditor is coming and talking to XU and MU and telling, you both are the partners, pay me the money. Now is MU liable in this case? Tell me.
Liable.
Sorry? Can you repeat?
Liable.
Liable. Okay. Why he will be liable? He is not the partner.
Partner by holding out.
Sorry. Partner in holding.
By holding out. Partnership by estoppel.
Partnership by estoppel. He did not deny the fact that I'm not the partner. He remained silent on this particular situation. So we will say that MU is also liable for this purpose. Okay. Let's see how we present this question. Second. As per section number 28 of Indian Partnership Act, partnership by holding out. This is the first main crux you have to mention. Partnership by holding out is also known as partnership by estoppel, where a man holds himself out as partner or allows others to do it. MU, did he hold himself as partner? No. Who said XU? And he let other people, he allows other people to introduce himself as the partner. He is then stopped from denying that the character he has assumed and upon the faith of which creditors may be presumed to have acted. Now he can't deny that I'm not the partner. You were the one who assumed, and the people have assumed that you are the partner. So whatever activity has been done, you are involved in that as a partner. A person may himself, by his words or conduct, have induced others to believe he's a partner, or he may have allowed others to represent him as partners. Now, in this situation, what has happened? By the conduct, by remaining silent, that is also a type of action. Silence is also type of an action. So, by remaining silent, he allowed XU to show others to represent him as a partner in front of the creditors. The result in both the cases is identical. Even though he shows himself as partner, MU, he says that I am only the partner, or XU shows that MU is the partner. The situation will be same. You can't deny on the fact that I am not the partner, and you will be liable just like a partner over here in this particular situation. Because creditors have supplied the good, placing a reliance that MU, the manager, is also the partner. So that was your provisions. First, you will mention over here. This is all your provisions, right? Then you'll write facts of the case. MU was said as the partner by XU. XU did not. XU purchased, or XU and MU bought goods of worth like some amount, which were 50 laptops from ZU, the creditor. The credit period expired. ZU filed the case against MU, XU and MU. All this will come in your facts of the case. Then you will write conclusion. In the given case, MU, the manager, is also liable for the price because he becomes a partner by holding out as per section 28 of Indian Partnership Act 1932. Even though if you don't mention the section, that will work, but you know that particular provision, that partner by holding out, you have to mention those words at least. Section number don't mention, no need. Clear? I have to go and check. Okay. Now, going ahead. Miss Lucy, while drafting partnership deed, taken care of few important points. What are those points? She want to know the list of information which must be part of partnership deed drafted by her. Also give list of information to be included in partnership deed. So while you are drafting a partnership, what all points should be kept in mind? What all things you have to mention in the partnership, that is asked over here, right? So this is almost your provision question, but we'll just discuss this. Miss Lucy, while drafting partnership deed, must take care of the following points. So, what all things? No particular formalities are required for agreement. No specific formalities are required. Then it should be in writing or formed verbally. Anything works. Either in your writing or verbal. Both will work as a partnership agreement, partnership deed. The document in writing contains various terms and conditions as to relationship of partners to each other is called as partnership deed. So whatever document you write where terms and conditions, relations, etc. is mentioned, so that time you will call that as partnership deed. Partnership deed should be drafted with care and be stamped according to the provisions of Stamp Act 1899. So you can only write that partnership deed should be carefully drafted and stamped. This is only how much you have to write. According to provisions of Act, you can't remember all the Act's name. So it is okay if you write that it should be properly draft, carefully draft and stamped. If partnership comprises immovable property, the instrument of partnership must be in writing. So if you are involving some immovable property in your partnership, you have purchased a land where you are going to build a office, or you are going to set up a plant, factory, etc. So that you have to make in writing only. Partnership deed is compulsorily to be in writing, stamped and registered under the Registration Act. Okay. So all these key points one needs to remember when drafting a partnership deed. Then what all things, list of information to be included in partnership deed. What all things will you include? Name of partnership firm, name of partners, where the business is going to be taken place, what business you are doing, nature and place of business, date of commencement of partnership. All these relevant things you will be mentioning. Then for a fixed period, if you are doing a partnership firm, so that time you will also specify the duration, how many years you're going to work. Then capital contribution, how much each partner is going to contribute, that also you have to mention over here. Then you will be also mentioning how what type of business you are doing, what is the profit sharing ratio, that also you need to mention. Okay, if admission happens, what are the terms and conditions? If retirement happen, what all terms and conditions will be followed? What is the rate of interest on capital, on drawings, on loans from partners? All these things you have to mention. Okay, any 6-7 points you should remember. That's it. Not much required from you people. Not much expected over here. Okay, so name of partnership, name of the partners, name of all the partners, their residential address, etc., their age also is to be mentioned. Then you have to write nature and place of business of partnership firm, date of commencement of partnership firm, period of partnership firm, capital contribution, rate of interest for drawing, capital loan, admission retirement provisions, profit sharing ratio. All these are your simple points which you can remember. Okay, this till here also, if you remember, that is okay. What all other points are given? Provision for settlement of account in case of dissolution. If the firm dissolves, what all provisions are there? What things we will be doing? That is also to be maintained. Then provision for salary, commission payable to partners, if any. If you are going to give some salary to the partners, that is to be mentioned. Provision for expulsion of partner in case of gross breach of duty or fraud. If some fraud is done by any partner, what all things, what provisions are there to remove a partner, expel a partner. Note, Miss Lucy may add or delete any provision according to needs of partnership firm. So any of the provisions you want, you can add more than this. Or if you want to remove any of this, you can also remove. Okay. I hope this is clear to you people.
Yes, ma'am.
Okay. Now, let's go ahead. Now we'll go to unit number 2. Relation of partners. Now, state the modes by which a partner may transfer his interest in the firm in favor of another person under the Indian Partnership Act 1932. What are the rights of such transferring? Now, what are the modes? How a partner can transfer his rights to another person in a firm? We have to see. So, section number 29 of the Act provides that a sharing partnership firm is transferable like any other property. Like you transfer the properties, you can also transfer the share in a partnership firm. How we will be transferring? But as a partnership relationship is based on mutual confidence, the assignee of partners' interest by sale, mortgage or otherwise cannot enjoy the same rights and privileges as the original partner. Whatever rights were there to the original partner, same rights and privileges will not be available to the person who is acting as a partner, who has been transferred all the rights. Okay, this 2 points you have to mention, that in the Partnership Act you can transfer the right just like another property, but the relationship that will be based on partnership relation is based on mutual confidence. So the assignee will not have the same rights in respect of your sale of property, mortgage, etc. Now, what all rights are given? Let's see. The rights of such a transferee are as follows. During the continuance of partnership, such transferee is not entitled. Now, these rights are not available to interfere in the conduct of business. You can't interfere in the conduct of business. You have been transferred. So, you look into the business, like you just do the business. Don't interfere in all the things. To require accounts, you can't ask the accounts also. To inspect books of accounts, you have been given the time, like for 10 days you have to act as a partner. You have been assigned as a partner, so you don't get into the books of the firm and check what is there in the books. He is only entitled to receive the share of profit of the transferring partner, and he is bound to accept the profits as agreed by the partners. That is, he cannot challenge the accounts. You can't check the books, you can't check the accounts, you can't challenge the accounts also. Okay. Now here he is only going to receive the profits of the transferring partner. Whatever profits that person was getting. If A is transferring his share and A, B, C were in the ratio of 5:3:2. Now A has transferred his share to P. So P will also go at only 5/10 of the share. He can't go and say give me 6/10 of it. You can't go and say more than it, or you can't challenge the books also, challenge the accounts of the company. If they say 5/10 of the share, half of the share of the profit is 2 lakh rupees. So you can only take 2 lakh. You can't tell them give me 2.5 lakh. I will check the accounts, etc. You don't have the permission. Then on the dissolution of the firm or on retirement of transferring partner, the transferee will be entitled against the remaining partners. What he will be entitled? To receive the share of the assets of the firm which the transferring partner was entitled. So if transferring partner is retiring or the dissolution of the firm is happening, whatever rights were there to receive the money, right to receive the share of assets or right to receive the income that the transferring partner had, same will be given to this assigning transferring partner. The new partner who is assigned here, whatever rights of income were there to Mr. A, now the same rights will be there to Mr. P. When A retires or firm dissolves. Okay. Whatever share will be there in the property, in the house, in the office, money, etc., your jewelry is there or anything is there you have kept for your firm. All these things, your partner will also have the same right. Transferee partner will have the same right. And for the purpose of ascertaining the share. So you can also ascertain the share what is there. If 5/10 is your share, you can see that 5/10 is given to you. He is entitled to an account as from the date of dissolution. So when the dissolution happens, P's account will be created. P's account will be created in the books of accounts, and whatever money is to be transferred to A, now that will be transferred to P. Then what they have said further, by virtue of section number 31, no person can be introduced as a partner in a firm without the consent of all the partners. A, B, C, both all have to give the consent. Like A is appointing P. So B and C have to give their consent. Okay, P will now be the partner. A partner cannot, by transferring his own interest, make anybody else partner in his place unless the other partners agree or accept that person as a partner. At the same time, a partner is not debarred from transferring his interest. Unless other people are agreeing that you can transfer to this person your rights, till then you can't transfer the rights. And if a partner wants to transfer, he is free to do so, but with the permission. Okay, this two sentence you can write. A partner is not debarred or is not protected or is not disallowed from transferring his interest, but he has to take a permission from all the partners. And all the partners should agree to accept that permission. A partner's interest in the partnership can be regarded as an existing interest and tangible property which can be assigned. So whatever interest is there is the existing interest of that partner. And whatever is tangible property, what property you can see, if the company is having 2 guest house, so whatever guest house is there, that will be divided into 3 equal parts. Whatever tangible property is there, that will be assigned or that will be given to all the partners. Okay. Clear everyone? This question is clear to you people?
Yes, ma'am.
Okay. So the next thing is whether a minor may be admitted in the business of partnership firm. Explain the right of minor in the partnership firm. Yes, you people tell me what is the situation here. Whether a minor can be admitted as the partner of the firm.
For receiving benefits,
minor can be admitted only for the profits of the firm, right?
Yes, ma'am.
Okay, good. A minor cannot be bound by a contract. First thing when you will write, partnership is what? It is a contract. So when we are presenting our answers, we other students will also write that minor cannot be taken as a partner. But what is the first basic idea which we need to remember? A contract, minor cannot be a party to contract, right? A minor cannot be bound by a contract because a minor's contract is void and not merely voidable. It is directly void. You can't see that voidable means what? It is at the option of the person who wants to act. But if you are getting into contract with minor, that is completely void ab initio. So first statement, you will be relating it to contract act, that a minor cannot be bound by a contract because minor's contract is void. First point. Then you'll be writing, therefore a minor cannot become a partner in a firm because partnership is founded on a contract. So minor cannot be a partner of the firm because partnership is founded by a contract. An agreement is to be made, a contract is to be made. Now, though a minor cannot be a partner in a firm, he can nonetheless be admitted to the benefits of partnership under section 30 of that. You can write, but as per the provisions of Partnership Act, minor can be admitted only for the benefits, of the partnership firm. In other words, he can be validly given a share in the partnership profit. So you can admit that partner only for the profits. When this has been done, and it can be done with the consent of all partners, then the rights and liabilities of such a partner will be governed under section 30. So the rights and liabilities that are there is given in your section 30. If you want, you can mention this if you remember, or else you can skip it. Just directly go to rights of partnership. You have to mention that a minor will be admitted only after consent of all partners. And what are the rights of minor? Let's see. A minor partner has a right to his agreed share of profit and of the firm. If he says that a minor will be given a share of 2, right? A minor will be given share of 2. So that is what you have to give that minor, right? If A, B, C, D get into a partnership firm and your B is a minor. So if he's applied for or he employed for 2/10 of the share, you have to give him 2/10 share. He can have access to inspect and copy the accounts of the firm. So this minor can also be involved in checking the books of accounts, in taking the copies of books of accounts. He has that right. He can sue the partners for accounts or for payment of his share, but only when serving his connection with the firm and not otherwise. So if B wants, he can file a case against A, C, and D. If A, C, and D are not giving him the share, if 2/10 of the share is 2 lakh rupees, if A, C, D is not giving him 2 lakh, considering he's a minor, why will he need so much of money? Then that is wrong over here. And also he can sue the other partners if something is going wrong in the firm. If partners are doing something wrong in the firm, this minor also has the right to sue the other partners. On attaining majority, he may within 6 months elect to become a partner or not to become a partner. In 6 months period after becoming 18, becoming eligible, this minor has the right. If he wants, he can still become a partner, or if he wants, he can reject to become a partner. If he elects to become a partner, then he is entitled to the share to which he was entitled as a minor. If he says that, okay, I want to be a partner, I want to continue as a partner, he will be given the same share, 2/10. If he does not, then his share is not liable for any acts of the firm after the date of public notice served to that effect. So if he says, no, I don't want to become the partner, I don't want to continue as a partner of this firm, so whatever liability will be there, whatever profits will be there, that will be not given or not shared by this minor partner. Okay. Are the rights clear to you people?
Yeah. Yes, ma'am.
Okay. What's wrong with this one? Yeah. Now, is there any other right? Yeah. So a public notice has to be given that if in 6 months this partner has to tell, do I want to continue as a partner or not? Let's see the next question. Messrs. XYZ and Associates, a partnership firm with XYZ, as senior partners, were engaged in the business of carpet manufacturing and exporting to foreign countries. On 25th August 2018, they inducted Mr. G, an expert in the field of carpet manufacturing. Now, first we will process till here. XYZ Associates, a partnership firm with X, Y, and Z as partners. Messrs. XYZ and Associates. Right. Now, they have three partners. Who are these partners? X, Y, and Z. As senior partners, were engaged in business of carpet manufacturing. What business they are doing? Carpet manufacturing. 1 second. What's wrong with this? Now, as their partner, now they have introduced whom as their partner? Mr. G, an expert in the field of carpet manufacturing. This has been taken as partners. On 10 January 2020, G was blamed for unauthorized activities and thus expelled from the partnership by united approval of rest of the partners. Now, one partner was admitted on 25th of August 2018. And after 2 years, like nearly 1.5 years, it came to the notice of other partners that this person is doing some unauthorized access. He does not have access to our bank account. Still, he is withdrawing the money from our bank accounts, etc. Okay. So in this case, you will be saying that this particular partner is fraud and now we want to remove it. So all the partners have given the concern that we want to expel this partner. Now this expulsion also, it is to be mentioned in your partnership deed. What you have to do for expulsion, that is also to be mentioned in your partnership deed. What have they asked us in this question? Examine whether action by the partners was justified or not. So was the action justified? XYZ were partners, and then on 25 August 18, they admitted X, Y, Z, and G was admitted, new partner. And on 10th of January 2020, he was removed or expelled, removed G. Now, whether the action is correct of partners, justified or not, tell me. We have learned section number 33. So even though if you have majority, you can't remove a partner. But in cases he has done something wrong, he has not done something in good faith, or what powers were given, he's doing against that powers, doing more than those powers, that time you can remove the partner. Let's see. Expulsion of a partner. A partner may not be expelled from a firm by majority of partners except in exercise in good faith. We are doing this, we have to remove Mr. G because he is fraudulently withdrawing the cash from our bank. So that is why in good faith, to save the money of the firm, we have to remove. Of powers conferred by the contract between the partners. He was not given the power to withdraw the money. Still, he is withdrawing the money. The test of good faith as required under section 33(1) includes three things. Expulsion must be in the interest of partnership. You are doing this for the benefit of partnership. Partner to be expelled is served a notice and a reasonable opportunity of being heard. Now, three things you have to remember. Expulsion is for interest of partnership or benefit of partnership firm. Right, first point. Then your second point will be the partner is given a notice, give a notice and give a reasonable opportunity of being heard. You will see in your further inter and final classes, they will be telling you ROBH. So reasonable opportunity of being heard. You have to give them an opportunity of being heard. Okay. Now first expulsion is clear to you people?
Yes, ma'am.
Now, if a partner is otherwise expelled, the expulsion is null and void. If you're not doing this in good faith, you're just removing the partner without any good reason, no majority is there, and you're just doing it because he did some, you have a jealousy with that partner, or that partner did not come to the office on time. For these small reasons, you can't remove. Okay. If it is for benefit of firm, You have to give a notice to the partner and also give him a chance to explain himself. Okay. So now do you think Mr. G should be removed from the partnership firm?
Remove.
Yes. We are doing it in good faith, but we have to give him a notice and we are doing it in the interest of partnership firm. And along with this, you have to give him an opportunity of being heard. Now, action by the partners of Messrs XYZ and Associates, a partnership firm, to expel Mr. G from the partnership was justified as he was expelled by united approval of the partners, exercised in good faith. We are doing it in good faith to protect the interest of partnership against the unauthorized activity, because he was doing some unauthorized activity. That is why we are removing him. Charged against Mr. G. A proper notice and opportunity of being heard has to be given to Mr. G. See, in your institute's answer, they will not write facts of case over here. They have not given in your textbook because they think that facts of case you will be copying down from question. So first you will write the provision. Then after this you will write over here facts of case from the question. And then you will be start writing the conclusion and analysis. Okay. We didn't see the B part. Let's see what B part was talking about. So what all factors one needs to keep in mind before expelling a partner? If you want to expel a partner, what things one has to determine, what has to be checked is given in the next question. What should have the factors to be kept in mind prior expelling a partner from the firm by other partners according to provisions of Partnership Act? So other partners, what all things you have to keep in mind? Let's see. Sorry. Second. So the following factors are to be kept in mind prior expelling a partner from the partnership firm by other partners. What other partners will see? Power of expulsion must have existed in a contract between the partners. I told you for expulsion, it is required that it is mentioned in your partnership deed. We learned in the essentials or provisions of partnership deed what all things should be included. So you should have the power, other partners should have a power to remove the partner who has defaulted, who is to be expelled. Power has been exercised by majority of partners. Majority of partners, if 5 partners are there, at least 4 partners, 3 partners should be agreeing to this. It has been exercised in good faith. You're doing this in good faith. Okay? Clear, everyone?
Yes, ma'am.
Okay, let's go to the next question. A, B, and C are partners in a firm. As per the terms of partnership deed, A is entitled to 20% of the partnership property and profits. A retires from the firm and dies after 15 days. B and C continue the business without settling accounts. Explain the right of A's legal representative. Now, A, B, and C were partners and A was to be given 20% of the share, right? We'll just assume that the remaining partners were given the rest of the share as 40%. 40%. Right now, this was given 20% share, and he said, I want to retire, right? I want to not continue from this firm. After he took retirement, 15 days passed and this man died, right? Mr. A has died. Now, A's legal representative will come and ask for money because it's just 15 days. The accounts have not been settled. A was not given the payment because the funds were not settled. The person was not available who is going to settle the accounts, etc. Valuation was not done of the property. Now, A's legal representative have some rights. Let's see what rights they have. Section 37 of the Indian Partnership Act provides that where a partner dies or otherwise ceases to be a partner, he retires, there is no final settlement of account between the legal representative of deceased partner or the firm with the property of the firm, then in the absence of contract to the contrary, legal representative of deceased partner or retired partner are entitled to claim either. Now, if in the Partnership Act it is said that if a partner dies or by any other means he takes retirement, ceases to be a partner. Ceases to be a partner means does not continue to be a partner, and final settlement is not done. Final settlement of account is not done. Then legal representative will be taking all the money, or he will be entitled to all the share of the retired partner or the deceased partner, dead partner or retired. Okay. Now, let's see what they have given further, what all things will be included in the share. Such share of the profits earned after the death or retirement of the partner, which is attributable to the use of his share in the property of the firm. So he will be given such share which was to be used for the property, or which was to be used by him. Such share of profits earned after the death or retirement of the partner, which is attributable to the use of his share in the property of the firm, or interest at the rate of 6% per annum on amount of his share in the property. Based on the aforesaid provisions of Section 37, in the given problem, A's legal representative shall be entitled at their option to 20% of share of profit as per the partnership deed, or interest at the rate of 6% per annum on the amount of A's share in the property. Now, let me take an example and tell you that. Now, A, B, C were partners. A retired. Let's say he retired on 1st of April 2024. Right? On 1st of April 2024, he retired. And after 15 days passed, on 16th of April, he just died. Okay, A died. Now, he was not given the settlement. When he retired, in his account, in his partnership final account, we know that there is partnership account. So, in his ledger account, he was due with 50 lakh rupees. Right? Now, 15 days have passed. He has died. And the books of accounts have not been settled. They come and settle the books of account on 30th of April 2026. Now, on 30th of April, if you are settling the accounts, what you have to do, either you have to give 1 month profit, or interest. Interest is to be given. Take it down. Yeah. Interest is to be given at 6% on the amount that was due, right? For that 1 month, you have to give 6% interest per annum. 6% interest per annum is to be given for the amount that was due. So if in 1 month they earn a profit of rupees 3 lakh, right? They earn a profit of rupees 3 lakh. So either they will give 3 lakhs 20%, that is your 60,000 rupees, that is to be given, or you have an option that on 50 lakh rupees, give 6% interest for that particular year. Like 1 month's interest you have to give 6% per annum, you have to calculate. Okay, I'll write it over here, interest at 6%. So 1 month profit, if you are considering to, what was consideration? 3 lakh. Yeah. If you are considering 3 lakh is 1 month profit, so 20% of this comes out to be 60,000. Either you pay this, or you have to pay 50 lakh into 6% into 1 by 12, right? You have to either give that percentage. Clear? So whatever is at the option, if you want to give 60,000, give your 60,000, or you have to pay this 6% on yearly basis, right? So if we go by this particular thing, it will be 6%. If I take, that will be around 3 lakh, and half of like 1 month of it will come around 25,000. So either you pay 25,000 of interest, or you pay 60,000 1 month share profit. That is at the option of the existing partners. Is this complete scenario clear to you people?
Yes, ma'am.
Okay. Let's go ahead. Let's see question number 5. Now, this will be again, I guess, on your minor question. Now, Master X was introduced to the benefits of partnership firm of ABC, with the consent of all partners. So X became the partner. He's a minor. Still, he was admitted as partner for the benefits. All the partners have agreed. After attaining majority, more than 6 months elapsed and he failed to give a public notice as to whether he elected to become or not become a partner. So he did not disclose that I will be a partner or not. Later on, Mr. L, a supplier of material to Messrs ABC and Company, filed a suit against ABC and Company for recovery of debt due. In the light of the Indian Partnership Act 1932, explain to what extent X will be liable if he failed to give a public notice after attaining majority. And the other one is, can Mr. L recover his debt from Mr. X? Now, here he has not given the notice within the 6 months time period, right? He has to give a public notice. If he wants to join, he will say, I want to join as the partner. If he doesn't want to join, that also is to be indicated. But now this Mr. X has not indicated anything. So let's see what the provision says. As per the provisions of Section 35 of Indian Partnership Act 1932, at any time within 6 months of attaining majority or of his obtaining knowledge that he had been admitted to the benefits of partnership, whichever date is later, such person may give a public notice that he has elected to become or that he has elected not to become a partner if the Don't write too much of this. Just simply write in 6 months of attaining the majority or being appointed as the partner for the benefits of the partnership firm, a partner, a minor, has to give a public notice that if he wants to continue as a partner in the firm or if he does not want to continue. And such notice shall determine his position as regards to the firm. So such notice will determine will he be the partner of the firm or not. Okay, give me 1 second. However, if he fails to give such a notice, he shall become a partner in the firm on the expiry of 6 months. If you don't give the notice in 6 months also, you will be deemed, you will be considered that you are the partner of the firm. If the minor becomes a partner by his failure to give public notice within specified time, his rights and obligations are specified in section number 30, subsection 7, and they are as follows. So if you don't give the notice, you will be considered as the partner because 6-month time period was given. That is not a less time period. That is a good amount of time that is given for a minor to inform whether he wants to become a partner or not. If the minor does not inform that he wants to become a partner, it will be deemed. Deemed means it will be considered, it will be assumed that you are going to be the partner of the firm. Okay, even though you did not want to, but you did not deny, you didn't give a public notice that I don't want to be the partner. So you will be considered as the partner of the firm. Okay, so let's see what are the rights and obligations that a partner has when he does not give a public notice. It is given in section number 30, subsection 7. Okay. Now, he becomes personally liable to third parties for all acts of the firm done since he was admitted to the benefits of the firm. So from the day he was admitted to the benefits of the firm, from that day you will be considering that this person is also liable for all the benefits of the firm. Okay, even though you became a partner after 6 months of that expiry period, still you will be considered as the partner from the day you were admitted. His share in the property and the profits of the firm remains the same to which he was entitled as a minor. So all the rights and obligations will be same as the date when you were appointed as a minor. His share of profit, if he was given 20% of the profit, so he will now be also given 20%. In the instant case, since X has failed to give a public notice, he shall become a partner in Messrs ABC and Company and becomes personally liable to L, a third party. So now, even though if the loan was taken or if the goods were purchased earlier, still you will be liable because from the day you were admitted as partner, you had the time period, like if your minority age, you attain the age of majority, and in 6 months also you do not inform. So that time you have to say that even though I was not giving a notice, I didn't give a notice, now I have become a partner from the day I was first admitted. From the day you became the partner first time. Then what was asked next? Can Mr. L ask X to pay the liability? Now, In the light of provisions of section number 37, read with section 35 of Indian Partnership, since X has failed to give a public notice that he has not elected to not become a partner within 6 months, he will deem to be a partner after the period of above 6 months. So, if you are not giving a notice in the contradictory that I don't want to be a partner, you will be considered as partner. Therefore, L can recover his debt from him also in the same way as he can recover from other partners. So, as he can recover from other partners A, B, and C, same way you can also ask X to pay the loan. Okay. Is this question clear to you people?
Yes, ma'am.
Okay. Let's go ahead. Let's see the next one. Mr. A, transferor, transfer his share in a partnership firm to Mr. B, transferee. Mr. B is not entitled for few rights and privileges as Mr. A, transferor, is entitled there. Now, discuss in brief the points for which Mr. B is not entitled during continuance of partnership. So, A is the transferor of his share in the partnership firm to Mr. B. And B is not entitled for a few rights and privileges. We have already seen what rights are not allowed. Like you can't check the books of accounts, you can't ask them for the accounts, etc., your maintenance, etc. things. You can't ask them. So, what all rights and privileges are there available for the transferee? We have to again check that question. Okay. Let's see that again as per section number 29. A transfer by a partnership or by a partner of his interest in the firm, either absolute or by mortgage. He says like for a 10 days period or like he transferred it forever. That type of transfers are allowed. Or by the creation of him of a charge on such interest does not entitle the transferee during the continuance of firm to interfere in the conduct of business. So you can simply write what we wrote in the previous one. You cannot interfere in the business to require the accounts, to inspect the books of accounts. You can also, you don't have the power to require the accounts. You can't tell them, I want to check the books of accounts. You can't see the books of the firm. But you are entitled to receive the share of profit, but also entitles the transferee only to receive the share of profit of the transferring partner, and the transferee shall accept the account of profit agreed by the parties. Whatever was written in the agreement that A, B, and C will be sharing the profit in 5:2:3, and now A transferred to P. So P will have to accept the 5 shares of the profit, 5 by 10th share of the profit. Okay. In the given case, during the continuance of partnership, such transferee, Mr. B, is not entitled to interfere with the conduct of business, to require accounts, to inspect the books of accounts of the firm. Okay. Is this clear? But Mr. B can recover the money. Whatever share was there of Mr. A, he can get that money. He will be entitled to that money. But he cannot challenge the books of account. Whatever amount these 3 partners will give, other partners will give, he has to take it. However, Mr. B is only entitled to receive the share of the profit of the transferring partner, and he is bound to accept the profits as agreed by the partners. He cannot challenge the accounts. You cannot challenge the books of accounts. You will have to agree with whatever things they are giving, whatever share they are giving. So suppose if A, B, and C are in the agreement of 5:3:2 and A has transferred to P. P will be given 5/10 of the share. B and C say that the profits of the year are 20 lakh rupees. Right? So if 20 lakh is there, you will be given only 10 lakh rupees. Right? 5 of 10 share. That is your half of the share. Then even though P knows the profit is not 20 lakh, the profit is 25 lakhs. He can't go and tell them, give me 12 lakh 50,000, half of the profit, that is 5/10 of the share. Because he does not have the right to check the books, to challenge the accounts, to inspect the books of accounts, to interfere in the conduct of business. Okay. Are all the questions of unit number 2 clear to you people? Okay. Let's move to unit number 3. So the question, these are your third unit, that is registration and dissolution of your partnership firm. What is the procedure of registration of a partnership firm under the Partnership Act 1932? So what is the procedure that we had learned earlier also? We saw that one needs to get it registered, have to go to registrar of firms, then file a partnership deed. All the terms and conditions are to be written. Details of the partners along with their address, their age, etc., where they live, they are resident of India or not. All these things are to be mentioned over there. Then you have to take the approval. It will be written in the registrar of firms. The name of the partnership firm will be written. All this includes in your procedure. Let's see how we have to apply. The registration of a firm may be effected at any time by sending by post or delivering to the registrar of the area in which any place of business of the firm is situated or proposed to be situated. A statement in the prescribed form or accompanied by prescribed fee stating the firm's name, principal place of business, name and place of all the person who are going to carry on the business, date when each partner joined, names in full and permanent address of partners, all these things is given. So now first what we will do, we will be sending by a post, right? You have to send by post or you have to go to the registrar's office and deliver in which your place of business is there. Suppose your place of business is in Bangalore, right? So you have your place of business in Bangalore. So you will go to Registrar of Firms Bangalore, right? There you will go and file your particular return. There you will tell your partnership deed, go and give it to them or send it by post to them. Place of business, wherever it is, near to that, whatever registrar of firms is there, there you have to send it or go and give it. Then, or if you don't know today that we are going to do the business today, but you are seeing that it has been proposed that we will be setting up the business in your particular area, like you can say in your area of Bangalore or Pondicherry or Hyderabad, etc. So you can just inform there also, like if you want to do the business in Hyderabad, you have not decided yet, but you are predicting that your business will be done in Hyderabad. So there you can go to Registrar of Hyderabad and give them the partnership deed. Okay. Now in this partnership deed statement, what all things you will be mentioning? Let's see them again. You will be writing firm's name, place or principal place of business of the firm. If you are going to do your office in 2-3 places, so you have to write all the places. Name of any other place where the firm carries on business. I told you, if you are going to do the business in 2-3 places, you have to specify that also. Date when each partner joined the firm, when the partners have joined, that you have to give. Names in full and permanent address of the partners. You have to write complete name, father's name, surname. Then permanent address also you have to write. Duration of the firm. If you are going to do the business only for 10 years, so you have to write 10 years. That is your tenure. Okay, you have to mention that also. Clear? Statement shall be signed by all the partners or by their agents specifically authorized in this behalf. If your partner is not available in the firm, but their agent is available, so they will come and sign the partnership statement. Each person signing the statement shall also verify it in the manner prescribed. So that verification also is to be done. The people will come and come to your place or verify, or they will call you in the registrar of firms, or they will do some by KYC kind of thing. That verification is also to be done. Nowadays, they do the KYC kind of thing by sending an OTP or by asking your Aadhaar details, etc. So that is how verification is also done. A firm name shall not contain any of the following words. These words should not be included in the firm name. Okay. What are these words? Crown, emperor, empress, empire, imperial, king, queen, royal, or word expressing or implying the sanction, approval or patronage of government, except when the state government signifies its concern to use such words as a part of the firm name by order in writing. You can't use these words plainly. If you want to use this, you have to take the permission of the government. And if state government has given you the consent to use such words, that consent also should be in writing. They have given you approval, but the approval should be in writing. You can't just go with, okay, state government gave me the approval. Where is the copy of approval? You have to have a copy of approval, consent of approval. Okay. Is application for registration clear to you people?
Yes, ma'am.
Okay. When does the dissolution of partnership firm take place under the provisions of Indian Partnership Act? When does dissolution happen? Now, a firm will be dissolved when all the partners have decided that we don't want to continue this business. Dissolution of firm means discontinuation of the dual relationship existing between all the partners of the firm. Whatever business relation was there, now these partners of the firm don't want to continue. But when only one of the partners retires or becomes incapacitated from acting as a partner due to death, insolvency, or insanity, partnership firm, the relation between such a partner and other is dissolved. Now, there are two things here. Dissolution, we have learned this, dissolution of firm and dissolution of partnership, right? Now, if partner dies, now three partners were there, A, B, and C died. So now their relation with C has died. So that will be dissolution of partnership. But firm will not necessarily be dissolved. If A and B want to continue the firm, they can continue the firm, right? If A, B, C all are alive, they don't want to continue the firm. So that time dissolution of firm, okay? Or when only one partner is left in the firm, that time also dissolution happens. But the rest may decide to continue. So if others are deciding to continue, that will be just dissolution of partnership. Firm will not be dissolved. In such cases, there is in practice no dissolution. Particular partner goes out, but the remaining partners carry on the business of firm. This C partner went out, he died or he retired, he has gone out. Other partners can continue carry on the business. In case of dissolution of firm, on the other hand, whole firm is dissolved. When you dissolve the firm, entire firm will be dissolved. Partnership terminates as between each and every partner of the firm. So whatever partnership was there between A and B, B and C, and A and C, everything will be dissolved. Now, dissolution of firm may take place as an agreement, like you had written that now we want to dissolve it, that time as a result of agreement between all partners. Then by adjudication of all the partners or of all the partners but one as insolvent. All the partners became insolvent or one partner became insolvent. That time also your firm will be dissolved. By the business of firm becoming unlawful. If your business became unlawful, you were doing some drugs business. So that is unlawful business and the police has caught you. So your business is now going to discontinue. Partnership firm will come to an end. Subject to agreement between partners on the happening of certain contingencies. You had an agreement, effluence of time, completion of tenure which it entered to, death of partner or insolvency of partner. In the agreement, you had written that after 10 years of this business, we will close this. Or after we have done this project, we will close this partnership firm. Or else if one partner dies, we will close the firm. One partner becomes insolvent, we will close the firm. So in these cases also, your dissolution will happen. Then by a partner giving a notice of his intention to dissolve the firm in case of partnership at will and the firm being dissolved as from the date mentioned in the notice, or if no date is mentioned, as from the date of communication of notice. Now, if one partner comes and says, we want to dissolve the firm, I don't want this firm to continue, so you have to dissolve it. So whenever he gives the notice or from the date when this notice has been filed, whatever date is written in the notice, if he gives the notice on 10th of March, right? He gives notice on 10th of March. He says that now we will dissolve the firms. What the other partners will say? Wait for 21 days. The financial year will end. So we can stop the partnership. We can dissolve it from 1st of April 2020. So if it is mentioned in the notice that you will be dissolving it from 1st of April from that date, or nothing is mentioned, whenever he communicated. On 10th of March, he came with the notice, I want to dissolve the firm. From 10th of March, the firm will be dissolved. By intervention of court in case of partner becoming of unsound mind. If court interfered and said your partner Mr. A has become of unsound mind, A, B, C were partners, A become unsound mind. A has become of unsound mind. He has done something wrong. He has committed a crime. Permanent incapacity of partner to perform his duties. Now he is not capable. Or misconduct of partner affecting the business. He did something wrong. He did some fraud. Willful or persistent breach of agreement by a partner. He's continuously doing something wrong against the firm. Transfer or sale of whole interest of partner. He has given entire share to other partners. improbability of the business being carried on save at loss. Now, it is not possible for the firm to continue because you are doing so many losses. Now, you can't save the firm. So now the court will interfere and tell you to wind up, to dissolve the firm. The court being satisfied on other equitable grounds that the firm should be dissolved, or court comes to know from somewhere that these people are trying to or planning to do some fraud, in that case also they will ask for dissolution of the firm. Okay, clear everyone? Are the cases where dissolution of firm comes into picture clear to you people?
Yes, ma'am.
Okay, let's go ahead. Let's see the last question. Indian Partnership Act does not make the registration of firms compulsory, nor does it impose any penalty for registration. In the light of the given statement, discuss the consequences of non-registration. So, is it compulsory to get the partnership firm registered?
No, ma'am.
Yes, it is not compulsory that you have to get your partnership firm registered. Let's see what they have given. It is true to say that the Indian Partnership Act 1932 does not make the registration of firms compulsory, nor does it impose any penalty for not registration. So it does not give you any penalty, nor it is compulsory to get the registration. Following are the consequences of non-registration. If you don't get registered, you can't file a case. Then you can't fight that I was not given my share. Other people can't file a case against you. All these things happen as the as the consequence of non-registration. Let's see. Indian Partnership Act 1932 does not make registration of firm compulsory, nor does it impose any penalty for registration, non-registration. However, under Section 69, non-registration of firm gives rise to number of disabilities, which we shall presently discuss. So, let's see what are these. Although registration of firm is not compulsory, yet the consequences or disabilities of non-registration have a pervasive pressure on registration. In simple words, if you want to write, just write it. Even though it is not compulsory to get registered, but the consequences make the firms to get the registration, force the firms to get the registration, put a pressure on the firms to get the registration. Okay, I gave you 3 ways how you can present it. Now, what all disabilities will be there? What all things one can't do if your partnership firm is not registered? Let's see. No suit in a civil court by a firm or other co-partners against third party. You can't file a case in the civil court. Okay, civil courts we have learned in the first chapter, Indian Regulatory Framework. No case can be filed in your civil courts for if a partner by a partner or the firm against third party. If your debtor is not giving money, you can't file a case because you did not register the partnership. Firm or any other partner on its behalf cannot bring an action against the third party for the breach of contract entered into by the firm unless the firm is registered and the persons suing are or have been shown in the register of firms as partners in the firm. So your name should be there in the partnership register where names of all the partners of every firm is given. In other words, a registered firm can only file a suit against third party and the persons suing have been in the register of firms as partner in the firm. So in the register of firm, your name should be written as the partner of that firm and your partnership firm should be registered. Then only a firm or a partner can file a case against third party. No relief to partners for set-off of claim. If an action is brought against the firm by a third party, then neither the firm nor the partner can claim any set-off from the claim. Set-off. If the suit be valued to more than 100 rupees or pursue other proceedings to enforce the right arising from the contract. If you have not registered the firm, you can't settle the claims. If someone files a case against you and tells you to pay rupees 10 crore, so you tell that person to settle it off at rupees 8.5 crore. But you can't do the set off if your firm is not registered. Okay. Then your next is aggrieved partner cannot bring legal action against any other partner or the firm. If you have any problem with the firm has not given you the money. A, B and C are partners. B has problem. He is aggrieved. Aggrieved means who is disappointed, who has not been given the rights exactly. He has not been given the exact money or the promised money. A partner of an unregistered firm or any person on his behalf is precluded from bringing legal action against the firm or any person alleged to be or have been a partner in the firm. So B and the people of the B can like legal representative of B also. Okay, 1 second. Yeah. So the legal action against the firm or any person alleged to be or have been a partner in the firm, you can't take it. But such a person may sue for dissolution of the firm or for accounts and realization of his share of the firm's property where the firm is dissolved. So you don't have the right to file a case against the partners, but you can say that you will be filing a case and you will be telling them that we want to just like instead of filing a case against the people that are there in the firm, you will say that I want to file a dissolution, I want to dissolve this firm. That thing you can say, but you can't file a case against these people. Okay. But such a person may sue for dissolution of the firm or for accounts and realization. You can also ask them, I want the accounts of the firm. I want to see how much money will be received by me. I want to realize this properties. I want to sell all the properties of firm. Okay, that rights are available. Then third party can sue the firm. In case of an unregistered firm, an action can be brought against the firm by a third party. But third party has the right against you, because even though you're not registered, third party has the right that they can file a case against you. Okay. Clear everyone?
Yes, ma'am.
Okay. Now, we have covered your textbook questions. So, shall we cover the questions? So these were all the questions that were mentioned in your textbook, and we have covered all the 3 units of your Partnership Act. Okay, that's it for today's session. I'll see you in the next one.
We are having tests from 7 to